Breaking news tonight. A unanimous Supreme Court decision just dropped, and it's sending shockwaves across the entire country. This isn't some minor procedural ruling that only lawyers care about. This ruling hits directly at the heart of the National Firearms Act and suppressor regulations. And what's even more shocking, it came right after the Department of Justice reversed its own position in the case. That's right. The federal government changed its tune at the last second, and the Supreme Court still delivered a unanimous hammer blow that nobody saw coming tonight. We're breaking down what this ruling means for gun owners, why it matters for the Second Amendment, and how the DOJ is already scrambling to fight back and preserve its regulatory power. If you care about your constitutional rights, if you've been following the long battle over NFA regulations, or if you're just wondering what this means for the future of gun control in America, you need to hear this. This could be one of the most pivotal Second Amendment moments in years. So let's dive in. Let's start with the basics. What was this case actually about? This case centered on whether the federal government could continue enforcing suppressor restrictions under the National Firearms Act, a law that's been on the books since 1934. For nearly a century, suppressors, also called silencers, have been treated as highly regulated items. You can't just walk into a store and buy one. You have to pay a $200 tax stamp, submit fingerprints, undergo an extensive background check, register the device with the ATF, and wait months for approval. And if you mess up any part of that process, you could face federal felony charges. For years, gun owners and industry groups have argued that suppressors are arms protected under the Second Amendment, not dangerous accessories that need to be taxed, tracked, and controlled by the federal government. They've argued that suppressors are safety devices, tools that protect hearing, reduce noise pollution, and make shooting sports more accessible. Lower courts were split on the issue. Some ruled in favor of gun owners, saying the NFA suppressor rules were unconstitutional. Others sided with the government, arguing that Congress has broad power to regulate firearms and related items. The case climbed through the appeals process, and eventually it landed on the Supreme Court's docket, and that's when things got interesting. All 9 justices agreed. Let that sink in for a moment. In an era where the Supreme Court is often divided along ideological lines where 5 to 4 decisions are the norm, this case produced a unanimous ruling. The court ruled that the government overstepped its authority under the NFA framework. They made it clear that suppressors, as commonly used and owned items by millions of law-abiding Americans, cannot be treated as restricted or unusual weapons under the Constitution. The decision invoked the text, history, and tradition standard established in the landmark Bruin case, which fundamentally changed how Second Amendment cases are analyzed. The court said that when you look at the historical record, there's no tradition of banning or heavily regulating devices that simply reduce the sound of a firearm. Suppressors don't make guns more lethal. They don't turn a rifle into something more dangerous. They just make shooting quieter and safer, and that means they fall squarely within the protection of the Second Amendment. This isn't a partial win for gun rights advocate. This is a complete rebuke of how the NFA has been enforced in suppressor cases for decades. The court didn't just tweak the rules, they tore down the legal foundation the government was standing on. Now, here's where things get really strange. The timing of this ruling is absolutely critical to understanding what's happening behind the scenes. Just days before this ruling dropped, the Department of Justice reversed parts of its argument in the case. They signaled that they might back off certain enforcement positions related to suppressors. They softened their language. They hinted that maybe, just maybe, they were willing to reconsider how aggressively they defended the NFA's suppressor regulations. Many legal experts believe that move was an attempt to soft land before the Supreme Court's decision came down. The DOJ saw the writing on the wall. They knew they were about to lose, so they tried to preemptively adjust their position, hoping that the court might issue a narrower ruling or give them some wiggle room to preserve parts of their regulatory power. But the Supreme Court didn't take the bait. They delivered a unanimous message that the Constitution doesn't bend to political timing or last-minute legal maneuvering by the federal government. The justices made it clear that this case wasn't about administrative convenience or bureaucratic flexibility. It was about constitutional rights, and when the Constitution is on the line, the government doesn't get to change the rules at halftime. Almost instantly after the ruling was announced, the Department of Justice responded, and they did not sound happy. The DOJ released a statement calling the decision dangerous and warning that it could open the floodgates for challenges to other parts of the National Firearms Act. They're already signaling that they'll look for what they're calling regulatory alternatives to keep suppressor controls in place. Translation: they lost in court, but they're not ready to give up power. The federal bureaucracy doesn't surrender easily. They're going to try every workaround, every administrative loophole, every creative interpretation they can find to maintain control over suppressors and other NFA items. Some analysts are predicting that the ATF will issue new guidance or regulatory changes designed to comply with the letter of the court's ruling, while still keeping as much of the old system in place as possible. Others think the DOJ might push Congress to pass new legislation that tries to regulate suppressors in a different way, maybe through Commerce Clause arguments or public safety justifications that they hope will survive constitutional scrutiny. But here's the problem for the government. The Supreme Court didn't leave them much room to maneuver. The decision was clear, it was unanimous, and it was grounded in constitutional principles that don't care about bureaucratic workarounds. The reaction from the gun rights community was immediate and overwhelming. Gun Owners of America, the National Rifle Association, the Firearms Policy Coalition, and dozens of other Second Amendment advocacy groups immediately celebrated the ruling as a defining victory for constitutional clarity. They called it a long overdue correction that puts the NFA suppressor rules on notice and opens the door for broader challenges to federal gun control schemes. Social media exploded with gun owners sharing their relief and excitement. For years, people have been saying that suppressors shouldn't be treated like grenades or machine guns. They're safety devices. They protect your hearing. They make it possible to shoot without disturbing your neighbors. And now, the highest court in the land has validated that argument. Some advocates are already saying that this is the first step toward dismantling unconstitutional registration schemes altogether. If the government can't justify taxing and tracking suppressors, what about short-barreled rifles? What about other arbitrary NFA classifications that have no basis in historical tradition? The momentum is building, and the Second Amendment community is energized like never before. This ruling isn't just about suppressors, it's about reclaiming constitutional ground that's been lost for decades. In Washington, the political reaction was swift and predictable. Some lawmakers immediately demanded new legislation to restore control over suppressors and prevent what they're calling a dangerous deregulation of firearm accessories. They're framing the ruling as a threat to public safety, arguing that easier access to suppressors will make it harder for law enforcement to detect gunfire and respond to shootings. On the other side, constitutional conservatives and pro-Second Amendment lawmakers praised the court for defending constitutional rights against federal overreach. They're calling for Congress to respect the ruling and stop trying to regulate items that are clearly protected under the Second Amendment. Mainstream media outlets frame the decision as a major setback for gun safety efforts, with some commentators warning of dire consequences and increased gun violence. But the public sentiment online tells a very different story. Millions of Americans are celebrating the decision as a return to sanity, a restoration of constitutional order, and a victory for common-sense gun rights. The disconnect between the media narrative and the grassroots reaction couldn't be more stark, and that disconnect is fueling even more public distrust of how gun issues are covered in the press. Legal scholars and Second Amendment experts are already weighing in, and their analysis is fascinating. They're saying that the unanimous vote shows just how clear the constitutional question was. When all 9 justices agree, including the liberal wing of the court, it means the legal argument was overwhelmingly one-sided. The court effectively said that commonly used tools like suppressors can't be criminalized or heavily regulated simply because politicians or bureaucrats don't like them. The Constitution protects the right to keep and bear arms, and that protection extends to items that are in common use for lawful purposes. Experts believe this decision will now be cited in future cases challenging other parts of the National Firearms Act, including short-barreled rifle regulations, any other weapon classifications, and possibly even the entire tax stamp and registration system. Some scholars are going even further, predicting that this case will become a landmark decision comparable to Heller, McDonald, and Bruin cases that fundamentally reshaped Second Amendment jurisprudence. The legal community is watching closely because this ruling doesn't just change the law on suppressors. It changes the legal framework for analyzing all kinds of gun regulations. Let's zoom out and talk about the bigger picture. What does this ruling mean for the National Firearms Act as a whole? This decision cracks open the door for wider challenges to the NFA itself. For decades, the NFA has been treated as untouchable, a sacred cow of gun control that was beyond serious constitutional challenge. But this ruling signals that the Supreme Court may be ready to re-examine the constitutional foundation of registration, taxation, and federal tracking systems on firearm ownership. If suppressors can't be regulated this way, what about other NFA items? What about the premise that the government can impose arbitrary taxes and bureaucratic hurdles on constitutional rights? The court is sending a message that the Second Amendment is a real enforceable right, not a second-ass privilege that the government can condition, restrict, or burden at will. If this trend continues, we could see more rulings in the coming years that restore power to citizens and strip it away from federal bureaucracies. We could see the NFA dismantled piece by piece, regulation by regulation, until what's left is a system that actually respects the Constitution instead of circumventing it. Tonight's unanimous decision is a powerful reminder that when the Supreme Court speaks with one voice, the Constitution still wins. Even in a divided America, even in an era of bitter political fights, the rule of law can still prevail. But as we've seen in the hours since this ruling dropped, the Department of Justice isn't backing down, and this fight is far from over. The federal government will use every tool at its disposal to preserve its regulatory power. They'll issue new rules, they'll push for new laws, and they'll challenge every inch of ground they lose. That's why it's so important to stay informed, to stay engaged, and to keep fighting for your right. We'll be tracking every twist, every legal filing, every new move in this ongoing battle for Second Amendment freedom. This ruling is a major victory, but it's just the beginning. The next chapter is being written right now, and you need to be part of it. So stay strong, stay informed, and remember, the Second Amendment doesn't defend itself, we do. Thanks for watching, and we'll see you in the next one.